Good afternoon, Professor Hugh Collins, honorary guest, colleagues, friend, and fellow student. I'm Jan Liu, the Vice President, Research and Technology of City University, and the facilitator for today's lecture. First of all, I would like to welcome you all to the CTU Distinguished Lecture Series. I'm happy to have Professor Hugh Collins to deliver a distinguished lecture at City University of Hong Kong. Last month, Professor Collins is a Venerarian Professor of English Law, All Souls College, University of Oxford, and he is also a Fellow of British Academy. He studied law and got his bachelor and master degrees at Oxford University and received his Master of Law from Harvard Law School in 1976. He became a Fellow of Brasenose College, Oxford, from where he moved to be the Professor of English Law and the London School of Economics. And he has been a visiting professor at the New York University Law School and Boston University Law School. Professor Collins' research focuses on employment law, contract and commercial law, legal theory, human rights. His principal publications include Maxims and Law, The Law of Contract, 4th edition, Justice in Dismissal, Regulating Contract, Employment Law, 2nd edition, and a European Civil Code, The Way Forward, Network as Connected Contract, edited with an introduction, Labor Law, Law in Context series, with K.D. Ewing and McCollan Gain, European Contract Law and the Charter of Fundamental Rights, edition collection 2017. Today is our great honor and pleasure to have Professor Collins to have the lecture and the title Private Law and Fundamental Rights. May I now invite Professor Collins to the stage. Professor Collins, please.
Thank you very much for inviting me to this distinguished lecture. And I'm glad, in particular, Professor Howes, I'm grateful to his arm twisting to persuade me to come all this way to give a lecture. And we puzzled over what I should speak about, but the topic settled on was this one in the title, Private Law and Fundamental Rights, which is a very broad-ranging lecture over most of the law, in fact, and I hope that although there'll be some technical bits, you can sort of, those who are not deeply interested and familiar with the technical aspects of law will be able to gently ride over those and listen to the substance, which I think is important. Nor, I think, is the puzzling phrase I'm thinking of, though this one is puzzling, nor is the phrase false news. I've been trying to work out what false news means for a while now. Sometimes it just means fiction. Sometimes it just means inconvenient truths. And sometimes it just means some very silly ideas altogether. Now, the puzzling phrase I want to talk about today is the phrase which is hard to say and very hard to spell, which is the constitutionalization of private law. Although there's some uncertainty about what this word means, what this phrase means, what is absolutely clear is some people hate it and some people like it. Some people really loathe and worry about the project of the constitutionalization of private law, and some people greet it. So what does it mean, first of all, this phrase, constitutionalization of private law? I've tried to capture the meaning in the phrase up on the slide. In general terms, the phrase signifies the idea that the rules of private law, by which I mean the law of contract, tort, property law, that the rules of private law should be subjected to an assessment of their content by reference to the fundamental rights and principles of any relevant constitution or international convention or some other binding legal statement of fundamental rights. And, this is the hard bit, and if there seems to be some disagreement, incompatibility between the fundamental rights protected by the Constitution and the content of private law, contract, tort, property, if there's some disagreement between those two areas of law, then the private law has to be changed. So that the law of contract has to be adjusted so that it fits in with fundamental rights. So the process of constitutionalization of private law may be described as forcing the law governing relations between private individuals to align itself with, or at least to become compatible with, the constitutional rights that form the bedrock of the constitutional order. The picture I put up is a picture of an alignment. In Western France, the Gauls, I suppose they must have been, or the Celts, created these stone circles. You've seen pictures of stone circles like Stonehenge, but in Western France they created what the French call alignments. They create these long rows of stones going for miles over the hills. No one knows why they built it. Probably horse racing or something like that, who knows. Maybe some religious significance. But when the idea of the constitutionalization of private law was first developed, I think, in a group called the Study Group for Social Justice in Private Law. We produced a manifesto, and this was a manifesto which had to be agreed by people from every country in Europe. And the word alignement was good, because the French could agree to it, because it was a French word as well as an English word. So that's why we hit upon alignement, and we all knew about the way in which. So in this picture, the point is that you have private law, one line of stones, public law, a different line of stones, and they just have to parallel each other. Not meet, parallel. What does this mean in practical terms, in technical terms? Well, I've tried to look up a bit of Hong Kong law. Let's see, somebody will correct me, no doubt. So, what would this mean in practice? I think in Hong Kong, it would mean that the constitutionalization of private law in Hong Kong would demand that the common law that's preserved by Article 8 of the Basic Law must be adjusted, if necessary, so that it's consistent with the rights and freedoms protected in Chapter 3 of the Basic Law. So Chapter 3 has an impact on Article 8 and the protection of the common law. In the United Kingdom, the way it works is that private law, contract law, tort law must be interpreted so that it conforms to the Human Rights Act of 1998, which is a statute which enacts the European Convention on Human Rights as part of national law. And in the European Union, the technical issue is that when interpreting and applying European Union law, all courts, national courts and the European Court of Justice, must achieve results or outcomes that are compatible with something called the Charter of Fundamental Rights of the European Union. An odd name, isn't that? You think people have rights rather than the European Union. Maybe that's a reason for leaving it, but it's the people's rights there. So that's technically what's supposed to happen when constitutionalization takes place. Let me try to give you an illustration of what this means in just an example taken from a case last year in the Supreme Court of the United Kingdom, just so you get a sense of what this means. This was a very sad case. It involved a young woman who was disabled and found it very difficult living on her own, or indeed living with other people in a care home. So her parents decided to buy a small place for her, and in order to do that they borrowed some money from a bank and acquired the house, and they gave the daughter a tenancy, a lease, a short-term lease, giving her the right to live there. Sadly, because of financial difficulties, the parents were unable to repay the mortgage, so the bank foreclosed on the mortgage and gave the disabled daughter notice to leave the tenancy, to leave her flat, in accordance with the law. There was no doubt that the bank had followed the legal rules, the statute and the contract. But this was a difficult case because the consequence of the bank's foreclosure and eviction of the young woman would be that she would be out on the street, a disabled person with mental disability, unable to look after herself. A very hard case. So the question arose was whether this was a violation of her human rights. What right are we talking about? We're talking about Article 8 of the European Convention on Human Rights, the right to respect for privacy and right to respect for your home. It's the idea that you should be protected in your possession of your home unless there's a very good reason not to be so protected. Well, the case went through the courts. Our Court of Appeal dismissed her case very quickly. They just said, tough, freedom of contract, this is the law, end of case. The Supreme Court thought it was a much more complicated issue, though, and the Supreme Court decided unanimously, for once, that indeed it was right that her human rights, the human rights of the disabled daughter, were at stake. That the court had to take into account the fact that she was going to be evicted from her home. Nevertheless, the court decided that in the circumstances that interference with her rights was justified, because not only had the contract been complied with, not only had the statutory rules and processes been complied with, the court orders obtained and so on, everything had been done by the book, and that ultimately the court decided that it was more important to uphold the rules than create a special exception in this particular case. Well, I'm not sure I'm happy about that outcome. I felt very sorry for the young woman being evicted from her home. I hope somebody took care of her. If she goes to, the young woman, MacDonald, would have the right to go, if she has the money, to go to Strasbourg, to the European Court of Human Rights, and I don't know whether they would agree with the British court. I think they might well say that the court should have spent, at least given her extra time to find some alternative accommodation before eviction. But that's my guess. So there's an example of private law being affected by human rights. It's a simple case, really, someone being evicted from their tenancy because the bank is enforcing the contract, but ultimately the court upholds the law. But it does say that the human rights are applicable and might change the result in special circumstances, though this was not one. So that's an example of constitutionalization of private law. And the question is, why should anybody be worried about this? Is this such a subversive and dangerous doctrine? Is it going to create chaos? Well, people are very concerned about it. I don't think, in this case, they're particularly concerned about the mention of human rights or fundamental rights. I think that it's not that language. It's the linkage that is drawn, the connection that's drawn between fundamental rights and private law. I think many lawyers think that they have nothing to do with each other and should have nothing to do with each other. And that, furthermore, the worry is that if the fundamental rights are applied to private law, then that might start disrupting private law, and that we'll end up with cases being decided not by reference to the carefully drawn up rules of contract law and property law, but by some assertions of human rights or something like that. So this fear of constitutionalization of private law, I think, could be summed up in these 4 bullet points, 5 somehow. There's also, I have to tell you, within the academy, within the university, a fear that public lawyers are going to take over private law, that my colleague at Oxford, Paul Craig, the professor of public law, will start telling me what to think as professor of private law. We don't like that, of course. And there's also doubt by my more conservative colleagues about whether any good will come of this, whether the law might be improved. And there are also worries about the idea that private individuals can be duty bearers with respect to constitutional rights, a topic I don't have time to go into today. My objective today is to try to persuade you that the constitutionalization of private law, the idea of applying fundamental rights to contract law, tort law, property law, is a good idea, and that it will lead to beneficial results. The changes in the law, I would predict, will be fairly minor and marginal. They might make a slight difference in some cases, but nevertheless beneficial changes. And it's my view that the introduction of fundamental rights into private law reasoning has the potential, if used wisely, to adjust private law to the values of the 21st century. And in order to develop that argument, I think I need to go through 3 stages. First stage is to reflect a bit more about this distinction between public and private law. The second stage is to explain why the disruption is going to be minimal, why private law won't really be disrupted very much by the introduction of fundamental rights. Though here I have to explain that the reason for the minimal disruption is not the usual reason given, which is in the jargon that the usual reason that's given is that there will only be indirect effect. That seems to be a very bad argument, and I'll explain to you why that's a bad argument. But I agree with the conclusion that the disruption will be fairly minimal. And then finally, my third stage which will only be brief, is I'm just going to argue very briefly that the effect of applying fundamental rights to private law is likely to be beneficial and modernising, and indeed improve the compliance of private law with the ideal of the rule of law. So